Okay, so probably the number one question that I got in the last week or two is about reading cases. And specifically, given that Kitquels talks a lot about not spending too much time over preparing for class, not briefing cases, not rereading cases, what is it that you're trying to do? I'll give you a sampling of the actual questions that I've received. But this is kind of the broader question is kind of, should I read cases and what should I be getting out of reading cases, given that Kitquels is based on taking practice exams and focusing on the black letter law, which you can get without reading the cases. So here's one question: should I be skipping some of my class readings? I'm already in a position where doing all the readings takes up most of my time. I'm usually studying in between classes every evening and 4 to 8 hours on the weekends in order to do all the readings and assignments. And down here, by the way, I'm not briefing cases, just highlighting them, okay? I think, Sam, this might have been you. Reading cases is not super useful, kind of as we discussed, and I need to learn the rules and elements of rules. However, how do I derive these rules and elements? No, I'm sorry, this is Sean, if he's out there. I'm in week 2 of law school and I can't seem to understand where I'm supposed to find these critical rules. Elements is the readings, professors, lecture, outlines. This might be yours, Sam. To what extent do I know if I've done enough reading for class or prepared for class? If I can come up with a general idea, which you said is enough for my outline, would it be enough? I feel that professors ask a lot of questions that I would not memorize or even notice for them to read just once. Is it normal? So I think the very first student answered her own question, and I think there's a lot to this way. The main way I could reduce the reading is by looking at case summaries, though the cases aren't usually the long assignments, and skimming theory and descriptive stuff in the textbook. Now, that student has Civ Pro and LegReg, for which there's a decent amount of theory, so she was talking about skipping that. So let me take a step back before we jump directly into the tactics that I think will be helpful in coping with a big reading load, especially given that I don't say don't do the reading. One of the first things is, are you noticing the effect that peer and kind of professorial pressure are driving you to do? A lot of people talk about how many hours they're spending reading, their massive workloads, how much they're briefing cases, and some schools tell you you've got to brief cases, or the whole point of law school is to prepare for class. I don't want to get too touchy-feely, but think about where you're actually feeling it. There's a place where this stress collects, and it's important to kind of notice where that's collecting. Is it in your stomach? Is it in your head? Is it somewhere else? And then notice what actions that discomfort is causing you to take. When you hear that someone spent 5 hours last night briefing cases, does that make you jump and go, oh God, I'm behind. What am I supposed to do? I guess I should start briefing cases, even though Larry's written a million things about not briefing cases. Another way to flip this around is, can you explain clearly to yourself why reading cases is so important? Why rereading them, why briefing them is so important? Or are the sources of peer pressure to do that able to explain that clearly, other than the fact that they're doing it and that you're taking an indirect lead from these people who are walking off a cliff? Are you going to walk off with them? So I'm slowly moving from the mental game to something kind of more strategic in general. So some of you may or may not have read The 4-Hour Workweek by Tim Ferriss. And there are two things that he talks about in his book, which came out about 10 years ago. The first is the 80-20 rule, the Pareto principle, that this is a general, this isn't, this is more of an observation, right? And sometimes this ratio is skewed even more. 80% of outputs come with 20% of inputs. 80% of results come with 20% of effort. Or flipping it around, 20% of people own 80%. Well, it's even more skewed than that, right? The top 1% own very close to that. So if you aim that kind of lens at law school, all of this is sort of a reminder that not everything you do gives you equal output in the eventual grade that you get in law school. And at first, it can be hard to know that because you haven't seen the output yet. So not every study activity is equally important. And in fact, some study activities are not important at all. And as I've talked about before, law professors actively mislead you along these lines. They don't know, very weirdly, that there's a disconnect between what they're asking students to do and what they actually test on in class. And there are slight ego-driven reasons why professors put a lot of pressure on you to do the reading. It makes them actively feel bad, like people don't give a shit if people show up for class and just kind of pass on the readings. Nevertheless, whatever pressure you're feeling, it doesn't mean that that activity is important. Now, our nervous system may kind of react differently to that. When everyone else is doing something and we're not, we may worry that we're kind of missing out on something. So 80-20 rule. This second principle kind of leads even more concretely to the tactics on how to deal with case reading. So Tim Ferriss also talks about Parkinson's law, which is the idea that a job will take as long as the amount of time that you allocate to it. If you give yourself 5 months to write a paper, you're going to take 5 months to write a paper. If you're given 15 minutes to write a paper, you'll get it done in 15 minutes. That might be an exaggeration, but it's something like that. It was kind of originally a joke about inefficiency in a British government agency, but if you've seen it in your own life, this is a real thing. I mean, you've crammed at the last minute for something that you should spend months studying for, and very often you, the fact that most of you are in, hopefully all of you are in law school, means that last minute cramming sometimes can work for you. You can cram a lot of work into a small amount of time when you're forced to. So one of the ideas is to do this deliberately and in advance when you're dealing with case reading. So what I describe will be a choice, something that you do deliberately, an actual strategy. You have to make a decision that despite the pressure that you're feeling, that you're going to commit to focus on doing the things that matter, specifically taking practice exams and studying the black letter law, and not worrying about things that are less important, mastering all of the details of the case reading, looking good in class, even as those around you don't kind of do what you're doing. I do want to take a step back and not underestimate. Now, some of you join Kid Cools in the summer or even in the spring, and I've discussed this pressure that you'll feel and how awkward it is if you're on call and you're not like killing it in class, right? You're in front of a bunch of peers. It's the first time you get to kind of measure yourself, and it just feels bad if you don't seem smart in front of a bunch of other very smart people. That is kind of very concretely where you'll feel that pressure because you don't want to come off as an idiot. And the professor does get angry at people who are underprepared for class. But you have to choose which of the things you're going to focus on, because reading can take all of your time if you let it. So you need to make a deliberate choice to choose one thing over the other. And the thing is, not choosing is choosing. The default thing is you're going to feel the pull of that social pressure that works its way, starting with kind of social embarrassment by not looking good on call. But the end result of allowing that pressure to pull you will be doing lots of reading, not practicing the right things, and then not ending up with good grades, okay? So we've got the mental game, the pressure that you feel, the 80-20 rule, the idea that not every input to your studying results in a good output, and Parkinson's law that you can squeeze even critical tasks into a limited amount of time. And you can definitely squeeze less important tasks into a tiny amount of time. Now, I didn't say don't do the reading. There is some purpose to actually doing the reading. So let's turn to the specific tactics here. One, and this is one that I've written about before, is decide, study, or preview the law. And now that, I think some of this may have seemed abstract to some of you before law school, but now that you're there, I hope it's more apparent how this can actually save you time and heartache in trying to figure out the cases. In short, don't try to figure out the cases. Use a commercial outline to understand the cases. And I'll get into even more detail about what that means in a minute. Some of the terminology that I've come up with is new. I've really tried to think about what it is you're trying to get out of cases. So the manuals and Gilberts are usually keyed to common case books. So what you can do is read the very few lines in the short outline in a manuals or Gilberts, then read the case or skim it to confirm that that's kind of what it means, and then move on. If you want more detail, you can either flip to the long outline in the manuals or Gilberts, or there are some online case briefs, and as some of you have seen, I'm trying to work on video case briefs to make life easier for you, but I'm not going to get hundreds or thousands out there as I have other things I need to do. So then the second thing is, first thing is, okay, the 80-20 principle, by the way, that comes out of side studying the law is there is one thing, the kind of rule that you need to extract from the case. So instead of flipping through a badly written opinion, jump to the outline to get the rule and then try to understand the case. And short circuit reading for understanding and reading, replace that with reading for other things, but I'll talk about what I mean in a second. So the second thing is to use Parkinson's law to kind of time box or specifically limit the amount of time that you spend reading. Meaning that, and I think the kind of first question that I got, the woman who was reading all the time and reading 4 to 8 hours on weekends, don't read until you get it. And you'll see how this is linked to this. That is, don't read until you feel that you understand and have mastered the case. In advance, set the amount of time that you're going to spend doing the reading, and when you've hit that time limit, stop. Again, first, you can short circuit the need to understand by getting your understanding from the commercial outline. And, this is not really literature, and there's no award that you get for reading a case until you understand it. There is a real life skill kind of somewhere out there whereby when you become a lawyer, you may have to read cases and understand them on your own. The funny thing is that this is exactly how you'll do this in real life as a lawyer. Nobody just grabs a case and tries to understand it. If normally you will search for cases on Westlaw or Lexis, and they come marked up and tell you in advance what the case is about. You never just get a raw case. And I think some of you have seen this in your legal writing and research classes, is when you look at a case online, there are head notes and other things that actually tell you what the case is about. An attorney has marked up the case already and says these are the key parts of the case. These are the different holdings of the case. So you will do this exactly in this order. As an attorney in practice, you'll get kind of a quick headline about what the case is about, and then maybe you'll read the case to make sure that it says exactly what you need it to say. If it doesn't say something else, if there are other things that aren't damaging to the kind of case that you're trying to present. But I've been asked this question before, am I missing something? Is there some educational thing that I'm missing out on by not forcing myself to read the case and figure out the law on my own? And I think the quick answer is no. I mean, virtually nobody learns law for a brief or a case that they're working on totally cold. No one's just going to hand you a case that's not marked up. At the very least, Westlaw or Lexis does this a bit for you. So there's no value in reading until you get it, so don't do that. So this does result in a lot of skimming between these two principles. So skim. Now, a kind of bigger question is, what is it that you're supposed to get from the reading? And I've tried to make this a little more specific, and some of you I've already talked to a little bit directly about this. But some of the confusion about what it is that you're spending your time doing or why you're reading a case and what you're trying to understand from it comes from a fundamental confusion about what you're supposed to get out of it. So it's two things, and these are acronyms that I've come up with, RGA and FT. The first thing that you're trying to get from a case is a rule of general application. The second thing that you're trying to get from a case are fact triggers. These things, I have a lot more that I'd like to say about this in the future, but both of these things are fundamentally forward-looking and require a kind of active learning. More on this in a second. Okay. So with the rule of general application, when you read a case, if you do it cold, the idea is to extract the rule of general application. I literally just came up with this morning. I feel like this is, I tried to come up with just one word, but this is the best way to do this. This is a dumb Wu-Tang reference. I don't even listen to them. So you know what a holding is if you've been forced to brief cases or you've had legal research person tell you what it is. So what I mean by rule of general application is it's more than a holding, which is how the case is resolved. It's a rule that you can actually use to resolve future cases. So it's the holding, but it's abstracted one level, so it's not just about the immediate case, right? An example of this is Hawkins versus McGee, which I just did a case brief on. The holding is that the pain and suffering that Hawkins suffered was part of the expectation damages calculation already. No matter what was going to happen, the skin graft was going to include some measure of pain and suffering. When you cut a piece of skin from your chest and apply it to your hand, that's going to hurt no matter what. But that is very specific to Hawkins. You know, something about cutting chest skin is not super applicable to other cases. So in the case of Hawkins, the rule of general application is that you only get the benefit of the bargain. You don't get other things outside of the benefit of the bargain, and you don't get to count things that you give up, such as the kind of pain and suffering that you go through if you didn't get the full benefit of the contract. You don't get to count those other things that you would have lost anyway had the contract been fulfilled, okay? So that's an example of a rule of general application. It's not the holding or how the case is resolved. It's one level up, and it's the rules that you would apply to new facts on an issue spotter. Now, you get this from a commercial outline of the case brief because the RGA doesn't leap out of the case. In a common law court, the judge's job, although there are more forward-looking judges, and sometimes they will look to the future, the judge's job is to resolve the immediate case between the parties, so they don't try to articulate how the case might be used in the future. You might find some of that in dicta, or you might not, because sometimes dicta kind of gets you, is a little bit like the reasoning in getting to the holding. If it had been like this, it might have been different, but it's not like this, so it's that. You're not always going to find this in the text of a case. So it's actually work product. And a commercial outline kind of creates its outline from these rules of general application. Case briefs also can provide that for you. So this is exactly the value of a commercial outline or an outline that a student's already created for you, because they've worked on figuring out the rule of general application for you. And as I said, these things don't always leap out of the case. Okay, here's the second thing that you're looking for when reading a case. fact triggers. Again, this is looking to the future. So you've got your rule of general application, okay? You know the principle that you get the benefit of the bargain. This totally simple way, let's go back a step, to word Hawkins is you get the benefit of the bargain and only the benefit of the bargain. You don't get more than that. You don't get things that you would have had to pay for anyway. That's the rule of general application. Fact triggers are how you will know how to actually deploy the RGA in the future. So this kind of has two parts. One is the actual narrative that comes out of the case. What's the story there? What is it that sticks in your mind? Hawkins versus McGee is pretty hard to forget because it's a pretty vivid image of this poor 11-year-old kid who's got this hairy hand and it doesn't get fixed, and he just has a mangled, let me step back, the scarred hand that doesn't get fixed, and instead he has a mangled, bloody, horrible, hairy hand. That's an image that you'll really never get out of your head. And it's something that you remember a little bit easier than the abstraction of the rule of general application, that you get expectation damages and just expectation damages. You just get the benefit of the bargain and no more than that. And there's research, which I haven't cited here, but there's research that says the human mind is built to remember stories, to remember a narrative. So in other materials where I've said that when you're doing a case brief, what you want is a rule and then maybe a one line to remind you of what the facts are. That's why I suggest that, and that's why this is still something important to extract from the case, is that there's a story there, and anything reminiscent to that story is something that will help trigger the rule of general application for when you're actually doing an issue spotting exam, okay? There's something else that you can do, and this is a little more advanced, and we'll get into it. You might do it in class. You might find it in dicta in cases. But YOs, your own hypos, okay? So you start with a narrative that the case is actually about. The dispute between two parties, something bad that happens to one person. And you develop your own alternate universes where one or two things are tweaked at a time, and you figure out how the rule of general application may or may not actually apply to that case. So what are alternate facts that are like this case? If you get away from the hairy hand, what's another situation? You know, think of whatever it might be. You pay to get a car wash, and I'm not coming up with any good examples there. That could connect a car wash to a hairy hand. But this is like testing around the actual facts that you're given. What are different facts that might trigger the rule of general application? And what are different facts that are really close that might not call up the rule of general application? You know, in the case, so one thing like this for Hawkins is if you had the boy who had a scarred hand and hair on it, if this is something that he told the doctor, like, I'd like to have 100% good hand, which is what the doctor McGee had promised, and I can't have any hair on it because I'm a hand model and people are repulsed by hair on hands. I'm sorry for all of those of you who have very hairy hands. And I'll lose my other contract as a hand model if there's any hair on my hand. The scar they can put up with, although I get less money, but if there's a single strand of hair on my hand, no. So you get Hawkins, the skin graft takes place, there's hair on the hand, and Hawkins loses his hand modeling contract, does he get to recover for that? Now, there is the general rule that you get benefit of the bargain and only benefit of the bargain, but part of that bargain in the original case was the pain and suffering from the skin graft itself. There's a little bit of language in Hawkins that hints at consequential damages from Hadley versus Baxendale. And not only is the person that breaches a contract responsible for the benefit of the bargain, but known consequential damages. So in that case, the hand modeling contract is not part of the bargain. It's not already folded into the bargain the way pain and suffering is. It is something that Hawkins can recover. Okay, so you're making up facts that are like this case that might be in different scenarios, and facts that are really close but that are just different enough that the same rule does not get triggered. So this is an active way of learning as you read a case. I'll tell you that there's exactly one person that I've met over time who said she briefed cases and did very well. There's a woman that I met who went to University of Penn Law and graduated Summa. I looked it up later on LinkedIn. She really did, unless she's lying, which I don't think she is. But she didn't do the normal briefing cases. It's precisely this that she did. And in my mind, she wasn't really briefing cases. She wasn't doing the stupid summary that those who make you brief cases make you do. She was doing something like this. It was a very active form of learning. She was trying to figure out what's the rule that I'm trying to get out of this case, and what are the different ways that I might apply it. Okay.